So we talked about how a case is actually argued in front of the Supreme Court and then the Supreme Court actually making a decision. But the topic of this video is going to focus a little bit on what are some of the different sort of like thought processes that go in to how the judges actually rule and do their jobs. So the two schools of thought are judges that believe in judicial restraint and those that often believe in judicial activism. It doesn't always have to be this way. But typically, conservative justices tend to favor judicial restraint, and more liberal justices tend to favor judicial activism. So, the job of, in the eyes of somebody that supports judicial restraint, is that the job of a judge is to apply what's in the Constitution and not rewrite it. And again, this tends to be more of a conservative philosophy that there's no room for sort of a personal opinion in a Supreme Court sort of like ruling, that you have to go by what's in the Constitution. This is what we often refer to as originalism. And this tends to be something that people that support judicial restraint believe in very strongly. This is the idea that the only thing that should be guiding a Supreme Court justice's sort of like thought process when deciding a case is what the Constitution says. And that has to be the sole sort of like blueprint for the justice's decision making. That there is no room for like your own personal opinion about the case. That essentially you have to be guided by what the founding fathers wrote in the Constitution. That is the job of the justice, is to use the original words, not try to think about what the justices would think if they were the founding fathers would think about if they were alive today. Also, justices that believe in judicial restraint also tend to believe in what we call like stare decisis, which is essentially respect for precedent. That the Supreme Court has already ruled on a topic, an issue, that it's not good form to have like a new court, right? Like several years later, new justices overturn that precedent. That if the Supreme Court, years earlier had decided an issue, there has to be respect for that previous decision, and the Supreme Court shouldn't be in the business of overturning Supreme Court decisions that were made like previously. Right. So again, this is what people that support judicial restraint tend to believe in, and also their argument is because judges are like not elected and they're appointed, they really should defer to elected officials to make policy. Like to kind of paraphrase, like judges really shouldn't be getting like they should be restrained, as the name implies. They shouldn't be getting involved too much because they're not accountable to the people. That most of the decisions have to be left up to elected officials that indeed can be voted for and are accountable to the people. Um, Justices that support judicial activism sort of believe the opposite of everything on the left hand side of the screen. Their argument is that it's ridiculous, right, for us to use a document that essentially was approved in 1787 to guide us in modern disputes today. But the Constitution's like a living document. It's like a guide, but it can't be like the be all to end all to base legal disputes on today because the Constitution really didn't write all that much about a lot of the modern issues. That it was left vague intentionally for like future generations to sort of be able to interpret it and apply it to sort of like modern day issues. And that really the art of being a judge is helping to adapt the Constitution to modern times. It's not like a frozen document that's the be all to end all. It's like a guide is the best way to put it. And they sort of believe the opposite sort of approach. They believe that because judges are not elected, they really have a special responsibility to intervene, especially in situations in which minorities, whoever they may be, gender or racial minorities, are being oppressed. Because the majority may not support it, and politicians would be hesitant to intervene if they knew the majority sort of opposed their intervention. That because judges don't have to be worrying about getting elected, they don't always have to do what is popular. They can do what is right. Like Brown v. Board would be a great example of that. Politicians were hesitant to intervene because there were still a large portion of Americans that supported segregation in schools in the 1950s. But the Supreme Court thankfully didn't have to worry about what was popular because they didn't have to worry about being elected. So again, it's the old argument about like judicial restraint versus like judicial activism. And again, the best example I can probably give to show you this, just to deal with some of this, is like think about abortion and how controversial that is today. Someone on the judicial restraint side would argue that the federal government, right, the Supreme Court, couldn't really intervene in sort of Roe v. Wade because that's not a power that was given or a topic that was addressed in the Constitution. So essentially, the Supreme Court in the 1970s decision of Roe v. Wade was overstepping its boundaries because there was no guidance in the Constitution dealing with that. So that had to be like a state issue. Whereas the activists on the court would argue that that's silly for them just to ignore a really controversial, important issue just because the Constitution hadn't specifically provided guidance on it. And then one of the other differences with activism, I should have mentioned this, right, is that they look as it being okay to use like what foreign countries have done as like a reference point, and that's called like comparativism. It's like we don't have to just use our constitution when we make decisions, but like let's look and see how other countries have tackled this issue too. So, like again, another example I can give you to sort of compare some of these philosophies is a case we briefly talked about in the federalism unit called Roper v. Simmons. And this was a 2005 case in which the Supreme Court essentially decided that it was cruel and unusual to execute anybody in this country that was under the age of 18. And you can see this is an example that was part of the majority opinion written by Justice Kennedy that shows sort of what judicial activism is. We have affirmed the necessity of referring to the evolving standards of decency that mark the progress of a maturing society. So words that you see there that are like buzzwords that tip you off to the fact that this is more activist are like we evolve, we mature as a society. Like we're not like frozen in sort of our ideas and our thoughts. Our determination if death penalty is disproportionate punishment, sort of like unfair for those under the age of 18, finds confirmation in the stark reality that the United States is the only country in the world that continues to give official sanction to the juvenile death penalty. The court has referred to the laws of other countries and to international authorities as instructive or helpful in its interpretation of the Eighth Amendment's prohibition of cruel and unusual punishment. That's the comparativism piece. Like we've looked at other countries, and most other countries aren't executing minors, so like we don't think we should be able to do that either. So again, that's an example of judicial activism. Or again, one of the current justices on the Supreme Court, Sonia Sotomayor, basically remarked in her confirmation hearings when she was asked about this, because judges are often asked, like, do you support activism or sort of restraint? She said, whether born from experience or inherent physiological or cultural differences, our gender and national origins may and will make a difference in our judging. Sort of allowing there to be outside influences other than just the wording of the Constitution. That like there is room for sort of opinion and your own experiences to shape your sort of like decision making process. So again, this is one of the big sort of disputes involving justices today. Is it appropriate to be an activist? Is it appropriate to support judicial restraints? And you hear about this a lot when, especially during the Senate confirmation hearings.